Evening live from Houston. We do bring in immigration updates every Tuesday from 5 p.m. to 6 p.m. And we do take live questions every Tuesday. Emily, what do we have today?
Today, we want to talk about visa revocations. We're hearing from more and more people about this happening, particularly for H-1B or H-4 visa holders and F-1 student visa holders. The Department of State suggests that they've revoked maybe 85,000 visas this year. So we'll talk about why that's happening, what it means, what people should be aware of. And then dealing with visa stamping, particularly again, H-1B and H-4, with this social media vetting, they've canceled all these appointments. They're rescheduling appointments. Why are processing times expected to get worse at consulates, and how to prepare what to expect for that? Then we had the update today that the regulation for changing the H-1B lottery to a weighted selection process based on prevailing wage has been finalized. It will be published on the 29th. So we'll go through what happens in the upcoming lottery, when will it take effect, and what you need to be aware of for that. And then lastly, the social media vetting. It started with F-1 student visas. Now it's H-1B and H-4 visas. Is it going to become permanent for all work visas in the future, and how should people prepare for that?
First thing is, Emily, that revocations used to only happen if there is any new information that used to occur. For example, if somebody has a DUI, recent DUI, and they have a stamping, and we know we used to get the visa revocation. If there is any new information that is found that either this guy has committed some fraud or involved in a criminal activity that they were not aware of. But now we started seeing new trends somewhere in the December first week onwards, where even if the people have had the records previously and they got the stamping, they were all good. Now they are getting their visa revoked. There is no public statement from USCIS. There is nothing anywhere, but their visa is getting revoked. Now, it's very confusing to me. Now, in the early part of 2025, we got F1 visas revoked, and at the same time, their services was suspended. And of course, we know Stephen Brown and other people have went to the court and got it reversed, where they were successful in getting reinstatement of the service system. But of course, they are not successful in getting the visa revocation taken back. However, this time we have seen that they have not issued any press statements, but they just issued a visa revocation. Let's say, for example, somebody has a DUI 12 years ago, and after that, their visa got revoked. They went for stamping. They did the psychiatric evaluation. They got the medical evaluation. They got the visa. They disclosed everything, and after that, they got multiple times visa. But now their visa got revoked. Is there any public statement from the immigration or from the administration, DHS, anywhere?
No, definitely not. I mean, they have their random social media posts from the State Department reminding everybody that having a visa is a privilege and not a right, and we have the authority to revoke visas at any time, which they do. However, as you mentioned, these are people who've already disclosed the information. So it's not that there's new information that causes the Department of State to question whether you qualify. They've already determined these people qualify. In some cases, they even got visa stamping during the current Trump administration twice, and still had the visa revoked. Um, so that tells me this has nothing to do with actual public safety. This is more just a way to show the anti-immigrant crowd that, hey, look what we can do. We're going and revoking 85,000 visas. It means nothing, because the people that are in the United States, it's a prudential revocation, meaning that it doesn't take effect until they leave. And all they have to do is go for stamping, provide the information again, show the same documents again. There's nothing that's changed in the law. There's nothing that's changed in the documents. The crime hasn't changed. Yet we have to go through this extra hoop. So nothing's really changed. Nothing's been announced other than just this new administration is trying to be as anti-immigrant as possible.
So, Emily, what is your advice to people who previously we told people not to travel when the we are going for visa stamping? We said it 13 times at a stretch. Now, what if the guy already have a visa stamping? Would you suggest them to go, or what do you suggest them to do right now?
Yeah, I would definitely advise against it, particularly for anyone who's had any kind of past law enforcement interaction. So if you, even if you've, if there was an arrest, a citation of some sort, and it was dismissed, it's been expunged, no guilty finding, anything like that, still you should avoid travel because at any given moment, if you happen to be outside the country when they revoke that visa, now you're going to be stuck because you're going to have to wait to get a new visa interview appointment. That might take months to do. And then you're going to get a 221G as they review the documents and do all of this extreme vetting that they're doing. So it's a big risk to travel for anyone in that situation. So just because you have a valid visa stamp, the idea that they can take it away by revoking it at any time for any reason is enough of a risk to say you should not travel until this administration is out of office.
I just recommend everybody, even if you don't have a criminal record, just don't travel because they are changing the rules every month. We don't know what they're going to come. They're adding banning certain countries to ever enter into the country at all, and that list is growing too. So I definitely recommend not to travel, even if you have the visa stamping too. Um, Emily, with regards to the second topic, that we're expecting longer visa stamping timings, particularly in the consulates in India, though. We have seen that US consulates in India are backlogged significantly. And now, with the new social media vetting, we have seen that visas are already been postponed from December all the way to even October of 2026. Now, what do you expect for the people who are going forward when they are applying for the H1B or H4 stamping? Is that going to be like, is the times are going to get better or is the times are going to get worse?
Yeah, I don't expect anything to get better during the current administration. They are anti-immigrant. They do not want immigrants coming into this country. And an easy way to keep them from coming into this country is to not give them the visa. So anything they can do to make it more difficult by delaying appointment availability. And then once you do have an appointment, delaying the actual process because they're claiming they have all these different things they need to check, social media, and we're checking criminal records and all that sort of thing, which they were doing already, but now they're using as an excuse as to why they can take it their sweet time to process anything. So I would expect we're going to see additional administrative processing, more 221Gs. The process itself just taking longer as they claim they have to do all of these extra checks now.
Um, we've already covered on the lottery system. From the new lottery onwards, that's going to start in March of 2026. It's not going to be the old system. It's going to be only waged based. That means that there are four level of wages. Level one, which is the entry level. Level two is mostly the, like, you don't need any supervision. Level three is you're kind of managing some people, but then you have the level four where you're high level manager, where all these four levels are there. So people with level one wage will be only be given one chance. People with level two will be given two chance. People with level three will be given three chance. It's kind of not three, but you'll get like more chances to get the lottery uh, system though. So that higher the level of wage is, the more chances you will get in the lottery. That is what the new system will be. That is how the new quota system will be. Unlike previously, where you were being randomly selected, that is not going to be there. The regulations are going to be published in a day. They're not published yet, is it right? They'll be published in a day or two.
Right. Yeah, December 29th, I believe, is the official publishing date, but the advanced public inspection regulation is available, so you can read it and look at it. It's about 300 pages. And they made very clear they are intending for this to be used in the upcoming lottery that will happen in March 2026.
And Emily, do you expect some challenges in the court on this one?
Yeah, it's definitely being discussed right now because I think the biggest issue is that the statute passed by Congress, which created the H-1B program, um, makes no requirements that visas be favored towards high wage individuals, high prevailing wages. If we wanted to promote high wage individuals, they would likely qualify for an O1 visa, which has a wage component to it as one of the factors. So that's not what the purpose of this visa was. It is meant for jobs that just normally require at least a bachelor's degree. In a specific field of study. So adding this wage requirement to it that favors some wages over others is definitely not in line with what Congress intended. So that's kind of one of the major challenges to it. And then also the statute makes it clear that the visas should be distributed basically in the order that they're filed. And this is, and their way of interpreting that up until this point was, well, if they're all filed at the exact same moment, then we just do a random lottery. And that's how they filled in that gap in the regulations in the statute. But now they're claiming that we have the authority to change the order in how they're filed based on prevailing wage levels. So I think that could be attacked as well. So we might see this, even though, and also I think, this isn't the first time the Trump administration has tried to make a wage component to the H-1B. Previously, they tried to issue a regulation that basically went by highest salary first. So whoever had the highest job offer money-wise the visas would go there first and going down the line. That was struck down in the court, partly because it was issued as an interim final rule, meaning they skipped the notice and comment and tried to claim that there was some emergency situation that required them to forego that and go straight to issuing a final regulation. This time around, they did do notice and comment, but it's the fastest notice and comment I think I've ever seen in 20 years doing this. I mean, they started the regulatory process on September 24th, 2025, right after the presidential proclamation that added the $100,000 fee. And it is December 23rd, 2025, 90 days. That's all it took. And 30 of that time was them receiving comments. So they literally had 60 days where they reviewed 2,700 comments. Every single comment that opposed the rule, they basically said, we disagree, with very little analysis to it. So it's really questionable whether they actually considered the comments, especially because they didn't change anything in the final regulation. Normally, you announce your proposal, you take into consideration the comments that stakeholders provide, you make changes based on some recommendations, and then you issue a final regulation. It's slightly different than what was initially proposed. This one had 0 changes to it, which tells me that they just wanted to go through the motions of notice and comment just to get it out in time for this year's lottery.
Social media vetting is going to be permanent at this point of time, definitely until this administration is gone. It is going to be there unless some court comes and rules in our favor. We don't know after this administration is gone how many of these things will be carried forward for the next administration. It will depend upon the elections, who's going to win, if that guy is going to continue. But at this point of time, it looks like the social media vetting is going to be there. The main problem for a lot of the applicants is nothing that there is any information that will be derogatory for them, but more this is a kind of delay tactic. The administration, because they cannot deny the application based on certain things, they are trying to delay it, so that delaying is going to eventually fall out where the person will lose the intention to come back into the United States. This administration is trying to do every effort where a person should not enter here on a work visa.
All right, should we go to questions?
Sure. Go ahead.
All right. So yeah, Nikhil says, how likely are these changes for the new wage-based H-1B lottery to be challenged in court? I do think that there are definitely discussions among attorneys looking to challenge this because it's not in line with what the statute says and what Congress intended. So we should likely see that in the coming weeks, I would expect, in the hopes of getting some sort of injunction before the lottery happens in March.
A lot of people's the priority dates is becoming, for some people, the priority dates is becoming current in January of 2026. What are the action that they need to do to get the green card, though? Here is the thing though, if your medicals were submitted more than before November of 2025, that means more than 2 years ago, that means that you need to have a new medical according to the regulations. So if you don't submit the new medicals, they cannot approve your green card. So you may want to submit the medicals. There are different ways of submitting the medicals. One way of submitting the medicals is you can submit along with the 485J supplement. 485J supplement is used when you file the 485 application confirming that there is a job offer with the company. It's also used when you're changing from company A to company B. Um, After the 180 days you are present in United States, sorry, in adjustment of status, you can move. That is porting of the employment. Now, some people ask, hey, I have already filed with the new company, or I'm still working with the same company. Can I still file the 485J supplement? Yes, you can. Now, if the medical you want the medicals to be reached to the file, that is a better way. If the company is not willing to, you can self-file the medicals. That is the best thing. What I suggest to you is that once you file the medicals, wait for 1 week or 10 days. If you don't get an approval, I want you to consider suing the USCIS. When you sue the USCIS, all you're asking them is that, look, 485 was supposed to be filed, adjudicated within 180 days. And your application has been pending for more than 2 years, I guess. Based on that, you should request the USCIS just adjudicate the application, take care of that application. And if you are interested in, contact Stephen Brown. He's the litigation chief in our office who is willing to take your case to approve your adjustment of status. Because if you don't, though, you know that the priority dates will move forward, move backward, forward and backward. So if you get this one resolved right now, then you don't have to worry about. Most probably, you don't have to come to this every Tuesday in the evening and listen to us, because once you get the green card, you may not need us. So definitely, I would like you guys to consider suing if the priority date is current and they don't act on your adjustment of status.
Sid Mohan says, what will be a good time to go for the first time H-1B stamping next year, given all the visa appointment uncertainties? The H-1B renewal is in September 2026. We don't recommend a good time for going for H-1B stamping. If anything, it would be after January 20th, 2029, when we have a new president, assuming the new president is not worse on immigration. So you should not go for stamping at all right now.
Tony118 from YouTube has this question. Received a notice of intent to deny NOID for the past arrest for a dismissed family violence case. How to respond? Definitely, a domestic violence case is considered a very serious offense in immigration, though. You have to definitely hire an immigration lawyer. What we closely look into is it's not the case is dismissed or not, whether or not you have admitted to have the wrongdoing. For example, if a lady has beaten the husband, um, and she told the police that she beat the husband and she felt guilty about it, she felt sorry about it, and the husband did not pursue the case, and the case is now dismissed. But she admitted to have committed the particular offense of beating the husband. Now, that is a very serious offense according to USCIS. So, even though the criminal courts may have excused for whatever reasons they may be, the immigration may still say that according to the police report, she admitted to the crime. They may still put her into proceedings. They may still deny the H-1B. So definitely, if there is a notice of intent to deny, that is a serious matter. We have seen RFEs to come for biometrics, but if it's a notice of intent to deny, you need to take it very seriously.
Sonali says, what is the probability of the Trump administration softening its stance on legal immigration in 2026? Well, I can't guarantee anything in immigration law. As an attorney, that would be unethical of me, but 0% chance that the Trump administration will soften its stance on legal immigration in 2026. There's just no way. This is just the beginning. So those of us that dealt with the previous Trump administration, it took about a year for things like this to start happening in high skilled immigration. Once it started happening, every month there was some new horror that was unleashed by the Trump administration, and it continued his entire 4 years. That's the exact same thing that's going to happen here. Where we're at is just the beginning. We've still got 3 more years of this, and it's going to keep getting worse. We're going to start seeing new types of requests for evidence. With H-1B petitions, L-1 petitions. We're going to see new reasons for denial. We're going to see changes in prevailing wage methodology. They're proposing a regulation dealing with I-140 petitions that nobody knows what's in it. So this is not going to get better. It's only going to get worse from here.
Vinod Kumar has this question. How many hours of unpaid volunteering for nonprofit can a H1B do? I want to be very careful on this, though. The nonprofit volunteering should be only, it should be real for non-voluntary. Let's say, for example, you own a restaurant, you are part of it, and then you are going there every day to volunteer for working in the restaurant. Is that considered to be volunteer? No, because you're expecting a profit from there. How about if you are working for, let's say we have in Houston called Telugu Culture Association, or if you are a member of a NATA organization, that's a Telugu organization, NATA or ATA or BATA or something like that, the Telugu organizations. So if you are spending a lot of time on it, I mean, what profit do you expect from these Telugu organizations? What profit do you expect when you go and serve in church or temple or mosque? None. You don't. I mean, we're not speaking about spiritual things, but we're only speaking monetary. So if you are doing that kind of voluntary job, I don't have a problem. If that voluntary job is 60 hours a week, I don't have a problem. But yeah, if your friend or relative have a restaurant and you are going there to do a voluntary job, I may have a problem because I don't think so there you're going for voluntary services. You're going there for some benefit. So definitely depending on the job though. If it is truly voluntarily, I don't have any problem you doing 60 hours a week.
Kunal says my priority date will be current in January. I already filed in April 2022. Should we complete the medicals now and keep them ready so that if USCIS issues an RFE, we can submit them immediately? Yeah, that's a great idea. When we saw that happen before in 2022 for October 2020 cases, we did recommend the same thing. You could even do 2 medical exams, get 2 sealed envelopes, send one in now before they ask for it as an interfile and ask them to place it in the file to hopefully avoid getting an RFE because now they have what they need. But keep the second one with you in case that interfile does not actually make it into the file, then you'll still have one available to respond to an RFE. But that is a great way to speed up the process so you can get your approval faster.
Emily, I need your attention in the question posted by Sequence Master from YouTube. His H1B has been revoked. And now his wife is outside the country, though. Can she enter into the country, though? Let me explain the background for the other people to understand. Of course, Emily knows it. Is that when people are, this is for, he has some reckless misdemeanor driving. So for the people who are getting their H1B revoked, their H4 dependents are also getting revoked. What do you answer? Whether she can come into the country, though?
Yeah, I would say we've definitely seen the H4 also getting revoked. It's not 100% across the board. It may be a good idea to check the status of the case for her H4 online in that SEAC system to see if it does say that it is revoked as well, and maybe she just didn't get the email notification. Otherwise, I don't know. Do you think it's safe for her to travel? Is she going to have difficulties at the port of entry if she even has the valid visa?
I would tell her not to travel right now. I would be watching the other people getting traveling and see if they're getting deported or they're getting allowed to come into the country. And then I will tell her, hey, look, the other people got deported, you don't come in. Or everybody came in safely, you can come in. So I would have her wait for a month to see what's going on. We do have this YouTube channel where people give his information. We do have a daily conference call where people come and give the information. We do get a lot of information. Not only that, we do have a law firm where like we have like 17, 18 lawyers. We exchange information. But right now, Our advice is to wait for a month to see if how the things are going with the other person, unless you want to be the scapegoat, which I don't want you to be scapegoat. Let's wait for a month to see how the things will turn out about other people.
Blue says, once the priority date becomes current as per the January visa bulletin, how much time does it take for the rest of the process to complete? It really varies. A lot of times we see that once the date becomes current, if they've completed all of the other steps, we start seeing a lot of approvals in the same month, which is great. But sometimes cases get stuck. Sometimes it takes 2 or 3 months. Sometimes it takes longer. Sometimes we have to do a supplement J to try to get things moving or submit the medical exam. Sometimes it's waiting for a visa interview appointment at the local office if they decide to interview the case. So it really is all over the board. It could literally be 1 month, it could be 12 months, anywhere in between. There's no rhyme or reason to it, unfortunately.
Does speeding ticket without any arrest or conviction lead to any visa revocations? No, if it's just a simple speeding ticket without any arrest or any detention, we are not expecting any visa revocation. We have not seen any visa revocation.
Babu Rajendran says, I'm in the US on a pending B2 extension with a change of status to H1B that has been filed. Should I make my social media public? It's definitely not necessary for you to do that for this process. Where you need to make it public is only when you're going for stamping at the consulate outside the US. USCIS does not require that you have your social media public. It doesn't ask for your social media handles like the DS 160 does, so it's not required.
My company is planning to file an H1B amendment plus extension, but the H4 and EAD for my spouse is expiring in 210 days. Can I include the H4 and EAD in the same packet? We strongly recommend you do include it with the packet. We have had no difficulties, even though if it's been expiring for more than 180 days in this particular situation, you can include it. We don't see that as a problem at all.
Himanshu says, what do you think will be the impact of the increase of the prevailing wage? Will it survive in the courts if they try to increase it drastically? Will they increase it like they did in 2021? So we know that there is a proposed regulation to change how they calculate the prevailing wages. We can assume that it's going to increase the prevailing wages since the Trump administration is claiming that H-1Bs are being abused and they should go to more high wage individuals. What we don't know is how exactly it's going to look because it hasn't been published yet. It's only been submitted as a proposal to the OMB, Office of Management and Budget, for them to do their kind of initial review. They have to clear it, and then they'll actually publish the proposed regulation. That will tell us what they intend to do. Then they'll have to wait for comments. So they'll give us 30 days to comment, maybe 60 days to comment. They'll hurry up and maybe look at the comments and then decide to issue a final regulation. Once that final regulation takes effect, then we'll see how they're going to actually implement it because they might change things from start to finish. But I would say it's guaranteed that the wages are going to be higher than what they currently are. Whether it will survive the courts is really how they go through the process. Does the methodology they chose make sense? Because for prevailing wages, the whole point of it is to make sure that the US worker and the foreign worker are being paid at the same rate, that the foreign worker is not undercutting US wages. That does not mean that the foreign worker must be paid higher than the American worker. They just need to be equal. And so if these prevailing wages are coming back higher, requiring companies to actually pay foreign workers more than American workers, I'm not quite sure what that accomplishes and whether it's in line with what Congress intended.
A question from YouTube is he's working as a managerial role stuck in India. If I continue work for India for 12 months, will I be eligible for EB1C or can I move on O1 or L1? Definitely, you have to consider that if you're stuck in India. But Are you on the payroll of the Indian company? Are you on the payroll of the US company? If you're on the payroll of the US company, you will not be eligible for the L1 visa or EB1C. You must be on the payroll of the Indian company, though. Now, other than that, you also need to meet the criteria what is required for EB1C. So definitely, it may be worth for you to consult an immigration lawyer to make sure that you are qualified for EB1C or not. So since you're already there, sitting there, you might as well do this extra thing and try to get the EB1C qualified.
Ami says, anyone get the national interest exemption for this $100,000 fee yet? Not that I'm aware of. If they have, no one has publicly posted it, but based on um, talk amongst immigration attorneys, a lot of people have submitted them. No response back on any of them. It appears to be just kind of a sham process at this point. So as far as we know, no one has gotten one.
I have this question is coming from Mohan. His advance parole is valid until 2029. When he recently traveled and entered back into the United States, they only given a DA, that is the I-94 only valid for 1 year. Does that mean he can only travel within this 1 year, or can he travel until the expiration of the advance parole? You can ignore the I-94. You can travel after the expiration of the I-94 as long as you have the advance parole that is still valid. You can travel. I don't see that as a problem at all.
Gaurav says my H-1B visa was revoked yesterday due to a 4-year-old case that was dismissed. I've had 2 renewals after that. Transferring my visa to a new employer, should I proceed or pause? So the visa revocation is a prudential revocation, so it has not actually taken effect yet. It doesn't take effect until you leave, which means it does not impact your current H-1B status and should allow you to transfer to another employer. That being said, I have seen this week one request for evidence so far that says that they're using the visa revocation as a negative discretionary factor, and they want the beneficiary to provide the positive discretionary factors so that they can be granted the extension of stay. This is the latest tactic of the USCIS. In earlier this year, they updated their policy manual to say that they have the discretion to deny extension of status, to deny change of status, to deny adjustment of status based on a list of discretionary factors that are not all inclusive. We have started seeing some for people that had past criminal activity where they were asked to go in for biometrics, and then they claim there's this derogatory information and you have to provide the court records and also provide proof of your positive discretionary factors. We have not seen denials of that. I have seen one, not my own case, but it was a large number of negative discretionary factors in that case. But we are starting to see it more and more often. And now they're using things like visa revocation or you being subject to a travel ban in order to say those are negative discretionary factors as well. So, all that to say, yes, you could proceed with the transfer, but be aware that you might get a request for evidence, number one, asking you to go to biometrics and then provide the court records, or have them just say that in their discretion, because your visa is revoked, they may want to deny the extension and give you the opportunity to provide those positive discretionary factors.
Chetan is asking this question. At the same time, BKG is asking the question from YouTube. Their question is this a wage-based lottery system? Is this applicable for non-profit higher education institutions that are exempt from the cap, though? This is the wage-based is only for the lottery system, though. That is nothing to do with the nonprofit and higher education institution. They don't come under the lottery system. Since they don't come under the lottery system, there is no priority who is going to get the H-1B, who doesn't get the H-1B. As long as you meet the minimum qualifications as required for the H-1B position, then you are eligible for applying the H-1B, and you don't have to worry about the wage levels, especially if you are working for nonprofit organization or nonprofit higher education institution. because this is only for the lottery system. There was never a lottery for the non-profit higher education institution.
AA Rush Talks Cute says, will perm dates move earlier due to fewer applications going forward? One would think that when the Department of Labor receives fewer applications, that processing times should improve because they have less work. That is not going to be the case. And we know that because over all of these last 5 years, the perm processing times continued to increase, yet the number of cases they were adjudicating remained practically the same year after year after year. There's no difference in the number of filings that they received. There's not some big backlog created because of higher filings. So the fact that we may see fewer applications will have zero impact on processing times.
Texas Ashutosh is asking, his 485 is pending. He has filed an EAD in advance parole. His EAD got approved for 5 years. His advance parole is not approved. How long do I think that the advance parole will be approved for a period of? It will be only approved for a period of 18 months. It will not be approved for 5 years. It's going to be only for 18 months now. It's a new rule.
RC says, will the new prevailing wage change affect renewals? Should one maintain a level 4 wage to secure an extension? And what percentage of wage increase will go into effect in the new rule? So they are proposing to change how they calculate prevailing wages. It's at the very early stages. It might take 3-6 months before it actually is finalized. So if they do change how prevailing wages are calculated, then yes, it would impact every case that requires a prevailing wage, which is going to be every type of H-1B, as well as E3, as well as perm labor certification. So anyone using a prevailing wage will use this new calculation unless you're able to use a private wage survey or something like that. We don't know what the percent increase will be because we don't know what their methodology is going to be this time around.
Jitin is asking question, can I file a EAD extension while the H4 is still processing? It still is not approved. Yes, you can. You don't have to wait for the H4 approval. You can file the H4. That's a better strategy. Otherwise, you may have to wait for a long time and then file the EAD. Then you have to take a long time to work. So if the H4 is pending, extension is pending, you can file for the EAD. Absolutely not a problem.
IT guy says, I filed for AOS recently and appeared for the biometrics. Do I need to make our social media profile public for verification? No, the 485 does not ask for your social media handles yet. That is something that is likely coming. But as of right now, it does not, and there's no requirement to make it public. That's only for people applying for the H1, H4, F1 visa outside the US at the consulate.
Question from handler. He's 485 pending. His start date is current. Um, he has submitted medicals in 2022. Will they be valid? No, they are not valid because they are more than 2 years old. And there is a rule change in November 2023. Anything after that are valid forever. Anything before that are only valid for 2 years. Since yours is September 2022, it's more than 2 years. Your medicals are no longer valid. You need to get the medicals to the USAs. They cannot approve your green card unless the medical is being filed. New medicals are being filed.
Oh, where did that go?
Go
This
ahead.
is a question. How do you provide the positive discretionary factors if they're asking about it for visa revocation? So the visa revocation just happens automatically all at once. They don't give you a chance to provide any positive discretionary factors. The extension of status or change of status applications or adjustment of status with USCIS, that's where you may be asked to provide those positive discretionary factors because they intend to deny your change of status due to potentially the visa revocation or past criminal activity or something like that. So you can be creative here. There's a list of things that they will consider, and you can add to it. You can provide anything you want, like your experience with your employer, your long employment history, your education level, the fact that you've attended all of your biometrics notices and always maintained your status, community involvement, paying your taxes, um, having US citizen kids. You can, you know, come up with any positive factor that you think that helps and provide evidence of that in the response.
Um, Question, people are asking, I'm a green card holder, can I travel? There are a couple of different questions that came up. I only have traffic ticket, but I don't have any other thing. And that is, did not involve any arrest. Can I travel? I'm a green card holder. I don't see any problem in you traveling. There's another gentleman who had a DUI, but all got cleared. He has all the documentation. Can he travel? I would go with precaution though. At the same time, I would have all the documents present to me at the time when you're coming, because they ask whether or not everything has been completed. Sometimes they can read some information, sometimes they cannot read. So make sure you carry all the documents when you're coming back. This, I'm only speaking for green card holder guys, not to the non-immigrant visa people.
Surrender says, I filed my extension in September 2025 in normal processing. Is it wise to proceed with premium processing or continue working based on the receipt? Assuming that your current I-94 has not yet expired and will expire soon, absolutely premium processing is recommended. The reason for that is we want you to get a decision before your current I-94 expires, because if that decision is a denial for some reason, because the Trump administration is coming up with new reasons to deny every week, it feels like, and your I-94 has not yet expired, it gives you more opportunities to fix the problem. You can refile the extension, you can file a transfer, you can file a change of status because you're still in status up to that point. If you continue working on the receipt and while it's pending your current I-94 expires, now you're in a period of stay authorized by the Attorney General, POSABAG, but when your H-1B gets denied, if it were to be denied, that immediately puts you out of status and you start accruing unlawful presence immediately from the day that the denial happens. That makes it a lot more difficult to get back into status. The only real option is to travel, and then to get a new H-1B, once you've traveled outside the US, the $100,000 fee kicks in. So that's a big risk to take when you have the opportunity to just upgrade to premium processing and get the result before your current status expires.
Do we need to disclose the potential visa revocation details in the DS-160? What all details we need to fill? Yes, you need to disclose the details of the provincial visa revocation in the DS-160. My question is that, why are you going? Don't go for stamping right now. The reason is that there is a reason why they revoked it. There is a chance you may never be allowed to come back into the United States. So I would definitely consult an immigration lawyer before you travel outside the country. And by in general, though, I take all the money and then say, what to you? All the money, consultation money, and then I will tell you one thing: don't go. That's all I'm going to tell. But of course, I'm going to tell in half an hour in a very nice, soft tone, saying, yeah, 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 yeah. Right? I understand what you're telling and all those things. And the end of the time, I will say, don't go. That's all I will say. I will take your money and tell that thing.
Um, Bodala Shan says, will there be spillover from family to employment-based categories due to the current travel bans? Not enough to make a difference. Stephen Brown and I did the calculations back on that. The number of green cards issued to those particular countries that are travel ban countries is quite low, to where it's just a drop in the bucket compared to the rest of the world. So it's not really going to be providing that many extra green cards that would have a drastic effect like we saw in October 2020, for example.
People are asking because of the Google has confirmed that they're going to file the perm application. Is there going to be an increase in the number of perm applications? Yeah, definitely, Google is going to is a significant part of it. So that it may have a bigger impact. It may have more perm labor certifications getting filed. So, I just
Um,
wanted to tell the news that the Google has stopped doing perm labor certification for a while, but they just made a decision that from now onwards they are going to apply the perm.
Lots of questions again on this social media and making your accounts public. The only time you are mandatorily required right now to make it public is if you are applying for an F1 visa at the consulate, an H1B visa at the consulate, or an H4 visa at the consulate. So all of the other situations people have mentioned in the comments, it is not required for you to make your social media public.
Um, Second. I'm doing PhD, but I got my H1B approved. Can I continue working can I continue as a full-time student and work on the H1B? If you're going to be you're going to comply with the H1B. Let's say if it's a full-time job, you're going to work as a full-time job. On top of that, you want to go to school full-time, we absolutely not a problem. You can do so.
Fun Magic says, is it possible to continue work for the employer while changing status from H1 to H4 along with the EAD? Yeah, so assuming your H-1B has not expired and you're working for the company that filed the H-1B and you're still working under the terms and conditions of that LCA, you can continue to work on your H-1B while you're waiting for your H-4 and your H-4 EAD to be processed, as long as the H-1B doesn't expire. Now, if you're doing that and your H-4 gets approved, but the EAD does not, then you have to stop working until you get the EAD. But other than that, you can continue working on H-1B as long as that H-1B is valid until the H-4 gets approved.
Um, Question is asked from KK from YouTube. He's asking the question: does prudential visa revocation has a lasting impact? Does it have a pending? Does it have an impact on the pending perm? Definitely, it doesn't impact the pending perm or I-140. It also asks question: does it impact H-1B extension? Yes, there is a, you will be called for a biometrics, but otherwise it's not a problem. You just have to go to biometrics. That's an extra step you have to take for you to get the H1B approval.
Raman says, are you seeing H-1B, H-4, and H-4 EAD being processed concurrently when filed under premium processing? Yes, we are still seeing them processed together. Sometimes it takes a few extra days for the H-4 and H-4 EAD to be approved, but they are still being approved in a relatively decent amount of time for a lot of cases. There's no requirement that they do that, so it's not mandatory. So there may be some cases where they do not process them together, but we are still seeing a number of them being processed together.
People are asking question whether it's safe to travel advance parole. We do not see any problem on traveling advance parole at this point. We don't.
My Nani says my H4 is in India with a 221G for the last 3 months. My visa expires in July. Can I apply for the extension in January? And is she still able to get it stamped on the previous application? So yeah, I mean, if you're in the US on H1B and she's in India waiting to get her H4, that her being in India waiting to get the H4 has nothing to do with you getting your H1B extension. So file it as you normally would. Once you get that approved, she can withdraw the previous H4 application, submit a new one based on your new extended H1B. It's likely going to get a 221G as well, but that way at least she'll have the 3-year validity of your H1B extension.
Anil Kumar Reddy has this question. If he's working for company A, can he has company B file for the perm labor certification for the future job? I don't see that as a problem. The company B can file a perm labor even though you have never worked for the company. The company B can file a perm labor. Absolutely not a problem.
Raval says, is the travel advisory solely focused on people applying for stamping? Is there any issue for stamped visa holders to travel outside the US, example, to Canada for a week? The H1 and H4 is stamped till 2028. Well, let's say you go to Canada for a week, and while you're there, your visa gets revoked prudentially because you have some past law enforcement interaction. Now you're stuck. You need to apply for a new visa. There's no appointments available in the near future. Um, is it worth it to do that? Or let's say you travel to Canada and then another travel ban comes down. There's no advance warning for those. And we've had an L travel ban specifically in the past. We had the H-1B $100,000 proclamation that was announced while thousands of people were outside the US and everybody was scrambling to get back into the country before it took effect. Now, of course, they backtracked on that and didn't apply it to people who had already had petitions filed, but it's a very stressful situation to be in. So travel at your own risk. If you have a valid visa stamp, we are seeing people getting into trouble where they get stuck, even when they had a valid visa, because something happens unexpectedly while they're out.
Did they increase the number of H-1B visas getting each year on H-1B? No, they did not. That has to go through the Congress, which is Parliament we call here as Congress. So there is nothing there right now at this point of time that says that we can. There's nothing there in the Congress that is increasing the H-1B numbers, and do not expect that coming in the Trump administration, guys. Questions with regards to the 498 dowry case in India. Will that have any negative impact on the citizenship application? It definitely might have a negative impact if you have a 498 case. You may want to take with you the immigration lawyers so that they can explain what exactly the offense is in India, and they will scrutinize that very thoroughly, though.
Avin says, my current I-797 is valid until July 2026. My employer plans to file an extension in February. Would it be better to choose premium processing or regular processing? I would do premium processing. You can always file it in regular processing and wait and see. And maybe in June, if it's still not approved, go ahead and upgrade it to premium. But make sure you do it so that you'll get the decision before your current H-1B expires in July 2026.
My L1 is maxing out in 6 months. My I-140 is approved in EB1C, and it's not current. Can I switch to F1 and then move back to L1 when it is current? You can switch to F1, definitely. Switching back to L1 requires, if you're going to max out on the H1B on L1 though, you have to spend 1 year outside the country to claim back any more L1 visa. So all you're doing is, if you're getting an F1, that means you're not stepping outside the country. You're still staying inside the USA. So that requirement that you have to be outside the country for 1 year, you're not meeting that requirement.
Shaw says, are adjustment of status from B2 to H1 still happening? Any updates on this? So for people who are experiencing a job loss situation and have filed a change of status to B2 at the end of the 60-day grace period, and then filing a change of status back to H1B when they do get that job offer, those are still being approved. We have not seen any changes in that process at this point.
My I-140 is in the process for the past 20 months. Currently, I'm on a 1-year H1B renewal, and my 6 years quota maxed out last year. So if I change my job, will my employer require a new I-140? Here's the issue, though. If you change a job, if the previous company withdraws the I-140, withdraws the I-140, though, that may affect you, though, because here is the thing. Right now, when you move to company B, you can get 1 year of the H1B because the I-140 is pending for more than 1 year. But here's the problem. You move to the new company, the previous company withdraws the I-140 approval How are you going to extend it after that 1 year period? After that 1 year period, because by the time they file a laborer I-140, and by the time the H-1B extension time comes in, you may not meet the requirement. So definitely staying where you are would be a better option for you right now.
VG says I filed my H4 and H4 EAD together in May along with the H1. The H4 got approved, but the EAD is still pending. Is it possible to expedite it, or what can be done at this point? It's been more than 7 months now. I mean, you can always request an expedite. They are at the discretion of USCIS. We don't see many expedite requests being granted, especially for EADs. So usually the best, most effective way of dealing with that situation is litigation. Our firm has been doing that in a number of cases over the years, particularly for H4 EADs, because processing times are increasing and you no longer have the automatic EAD extension. So that is definitely something to consider. You can reach out to Stephen Brown in our office, stephen@rnlawgroup.com.
Can I travel to Puerto Rico? I'm on H-1B visa. Absolutely. I don't see any problem. People will say, hey, you told me not to travel outside the country. First of all, Puerto Rico is not outside the country. It is part of United States. And guess what happened, Emily? One guy went to Costa Rica and then he got stuck there. And then he said, hey, you told you can go to Puerto Rico. Or I said Puerto Rico, not Costa Rica. They're different. Costa Rica is different. Puerto Rico is different. Puerto Rico is part of United States. Emily has some history with Puerto Rico. You want to tell Emily?
Yeah, my husband's family is from there originally, and his dad came to the US at a very young age from Puerto Rico. I know Puerto Rico is part of the US, but he moved to the States side before my husband was born. So,
So it's not within the United States. You have to fly, and but it is part of United States. It's just like Alaska, Hawaii. It is not a state, but everybody who's born in Puerto Rico is a US citizen automatically. So it's when you're traveling, but the only thing that we want you to take care of when you travel to Puerto Rico is make sure you don't travel through Mexico or some other country. That will create a problem. Now, a lot of people have issues. Hey, I want to go on, I have some free time. I want to take my kids. I can't go outside the country. Well, I would suggest you that you can go to Alaska. No, this is a wrong time to go to Alaska, but Hawaii may be a very good idea for you to go to Christmas time. I did went on one of the Christmas time. It's a beautiful weather right now in Alaska. It's not going to be winter time, so you can. Sorry, not Alaska. I meant to say Hawaii. You can also go to Puerto Rico. It's a very nice weather at the winter time. Not it's very south, so it's a very nice weather in the winter time. So you can go to Puerto Rico if you want to. Okay, not a problem. But don't go outside the country at this point of time.
Krishna says, if I change jobs with the same employer during my I-140 processing, does my employer need to restart or do a new I-140 all the way from step one? I'm on 1 year renewals due to H-1B max out. It really depends on what the job change is and if this is temporary or permanent. It is entirely possible for the process to continue, even if you change jobs temporarily right now. If the job offer that is on your labor certification and I-140 will remain open for you when you get your green card, then no process has to be started over in that situation.
Okay. Mm, This gentleman who's an L1 who wants to move to F1, he wants to retain some part of the L1 so that he can move back to L1 later on. One problem is, let's say, for example, if you're L1 and then you move to F1, there is some calculation where, let's say, for example, if you spend more than 2 years on F1, you may not be able to move back on L1 visa at all. So there are some time limitations when you can move back to L1. Now that's completely different for the H1B people. But when it comes to L1, there is a time period where you are, if you're outside on a different status for a while, moving back L1 might become a problem. So you may want to consult an immigration lawyer.
Arma says, my 485 has been pending for years. The priority date became current recently again. After a congressional inquiry, only my I-485J was approved. With the inquiry deadline nearing, what should I expect? This is EB2. Well, there's no deadline for an inquiry. USCIS can take as long as they want to respond to a congressional inquiry. They cannot respond at all. They can respond saying the case is within normal processing time. So the inquiries don't really help a lot currently. Since the 485J was approved, litigation is likely going to be a good next step if you're wanting to get the process over with at this point.
Naturalization process, if this question is coming from Surya, if there is any violations from the court order from outside United States, will that be a problem? Definitely, I want you to check with an immigration lawyer before you do any of the naturalization. If there is any contempt of court or any state violation from elsewhere in other countries, then you might want to be very careful. Anything else, Emily?
I think we're out of time for today. Thanks everyone for joining us. Hope everyone has a Merry Christmas, and we'll be back again next week on Tuesday.
Thank you very much.